why you need a will or a trust, which one you should do. I'm the one that has written this book called Will or Trust. Do I need a will or trust? In this situation, we have Jim and Rebecca. They are a married couple. They have 3 children. They're a blended family. Mary is Rebecca's daughter and Susan is Jim's, and they have one together, John. In this situation, if they do no estate planning, put nothing together, then they will not inherit from each other in the state of Texas. Jim does not inherit from Rebecca when she dies, and Rebecca does not inherit from Jim because of Texas intestacy law. So, of course, they need to do some estate planning. Well, let's say they just do wills. Well, wills cannot control property after someone passes away. Therefore, these are probable scenarios that might happen. If Rebecca dies first, she's going to have to go through probate. Yes, wills have to go through probate. Jim is going to inherit the property. Jim could remarry, let's say, Sarah, and Jim could redo his estate planning and leave all of his property to Sarah after he passes away. And then we're going to have to probate the estate again. See, there's 2 probates that have to be done when you just do wills, because wills have to go through probate. And then everything goes to Sarah, and Sarah, of course, puts in her will, her children, leaving everything to her family. So the wealth of the family does not end up going to Mary, John, or Susan, or their kids. It ends up going to Sarah. Here's another probable situation that happens very often when someone just does wills. Let's say Jim dies. We have to go through probate. Wills have to go through probate in order to be valid. Then everything goes to Rebecca. She inherits the property. She decides to do a new will and cut out Susan, not her child, and just leave to her 2 children, Mary and John. Susan gets upset, files a lawsuit because she thinks Jim and Rebecca, when they created everything, they had an agreement to leave everything to the 3. Well, it ends up going to a lawsuit, and attorneys sue, and attorney fees get paid, which end up happening that most of the state passes in attorney fees to attorneys. Common scenarios that happen with wills in a blended family scenario when we have issues. Now, let's say we just do a trust. Well, how does a trust avoid all this? Well, what we do with the trust, instead of you owning the property, the trust owns the property. And we put trustees in charge. In this situation, Jim and Rebecca, they want to be in charge while they are alive. Then they want John, who is related to both Mary and Susan, because they feel like he's the neutral party. But if he's not around, then they want a representation of both sides to be in charge. And in this situation, when we have a trust, what we can end up doing is controlling the property generation after generation. We could say, well, when Rebecca dies, everything goes to Jim, but Jim can't change the trust. It all has to remain in trust for his benefit, and the same when Jim leaves to Rebecca. And that guarantees when both of them pass away that everything will go to the 3 children equally. And then after that, it will pass on to the next generation if there is anything left. And that's why you do a trust instead of just wills.